What I recommend is, irrespective whether an individual or a corporate, take charge of your own agreement. Here, this session, I'm going to be explaining what are the certain things which you need to keep in mind, what are the certain things you need to go through the agreement before you actually go to a lawyer. So this session is basically going to explain you how you deal with each and every clause which is there in the agreement. These are clauses which are common in every agreement. However, they are way too important. So it is very important for clients to go through these clauses and interpret them. Rather than going from top to bottom, I am going to start from the very last clause till the beginning of a boilerplate clause. Now people do ask me what is so important about a signature clause. Two people are just signing and there are two witnesses to it. However, I would like to advise the clients that in the event the signing authority is that a company, it would have its official representative who would be signing it. A client needs to verify whether the person who's signing on behalf of the company has that valid authority. And how do you do that? You ask for a board resolution, a certified copy of the board resolution which empowers that person to sign the contract on behalf of the company. Also, in the signature clause it will be mentioned that so and so person is signing on behalf of the company, white board resolution dated so and so. Also, if it's a partnership firm, you need to understand whether that particular partner has the authority to sign behalf on the partnership firm itself, either by virtue of a power of attorney or consent of all the partners. For some reasons, if the law changes, rendering any clause of the agreement void, does the entire agreement become void? Yes, it could, unless there is a specific clause to it. So we insert a clause which says, in the event of certain circumstances which renders a particular clause invalid, it shall not affect the entire contract. The parties will continue to performing their obligations under the contract and the contract shall be valid. Variation clause. It's very simple yet important. What it says is that any variation in the future in the agreement shall be in writing and by mutual consent. And it is a very important thing to be implemented. Entire agreement sounds very simple, but it's a very effective thing. It means that this contract shall include all its schedules, its annexures. There were a lot of disputes earlier where parties would probably dispute upon a fact that a particular annexure did not form a part of the agreement. It is very important, hence, to have a clause to the effect that this agreement shall include all its attachments, annexures, schedules, etc. Let's assume there is a clause in the agreement which says that if there is a delay in payment beyond the stipulated time, then the aggrieved party shall have a right to charge interest. But let's assume that party chooses to waive off that particular condition in one of the things because there has not been a regular default in this regard. Does it mean every default will be waived off? The answer is no, and hence the clarity is required to this regard, and so we have the waiver clause. Anything which was negotiated or by virtue of oral or there hasn't been an MOU before this agreement shall stand invalid. Whatever has been decided now is a part of the agreement and that is full and final. Anything done before this shall not be rendered valid. Here, the parties can choose either to agree or disagree whether the other party shall be allowed or not allowed to assign or subcontract its obligations under the contract. Here the parties must agree whether they would like to opt for arbitration or not. And in case they would like to opt for an arbitration, whether it should be a sole arbitrator or a panel. And who would be the arbitrator? Either a retired judge of a high court or maybe any member of Indian Merchant Chamber of Commerce. This is something left to the party which they need to decide. Also, the place of arbitration. It could be either where the branch office of the company is located or maybe the head office. But this has to be decided mutually by the parties. In case of there is a dispute, which courts would have a jurisdiction is something which needs to be pre-decided by the parties. In case the parties need to communicate with each other, whether it could be a normal communication or maybe communicate for a breach or terminating an agreement, here it specifies who would be the contact person, what address, what form of communication, whether it should be a courier or by registered post alone or even an email would do. Termination would be whether the parties would have the right to terminate by will, by giving a notice of a stipulated time, or whether it will be terminated only in case of a breach, or whether the agreement would be for a period of stipulated time. However, equally important is post-termination. What would be the survival clauses post-termination? What would be the obligations of the parties after termination? Whether a party who has performed a part of the obligations, what kind of payments would be made to that party for the part performance. So, a post-termination clause is equally important as termination.